On February 16th, 2026, Pima County Sheriff Chris Nanos stood before cameras and made a formal announcement. The Guthrie family had been cleared. Not one single person in the family is a suspect. I am saying they are clear. We have cleared them. He confirmed that their phones had been processed and returned. Their computers had been processed and returned. Their home had been processed and returned. Their vehicles had been processed past tense. His words and the family had been ruled out in the first few days. That was February 16th. On February 26th, 10 days later, a CBS 5 crime journalist sent a direct inquiry to the Pima County Sheriff's Department. She had one question. What is the status of the vehicle Tommaso Cian drove the night Nancy disappeared? The response was a single sentence. All we can say right now, the vehicle is still part of the investigation. Hold that sentence, because everything in this episode turns on what it means and what it was carefully constructed not to say. The family had been publicly cleared. Every other piece of process evidence had come back, but the silver Honda CRV that carried Nancy Guthrie home on the last normal night of her life did not come back. It sat in the evidence lot for 32 days. No explanation, no press conference, no forensic update, nothing. This is the same sheriff who told the public about helicopter-mounted pacemaker scanners, who announced DNA results, genealogy pivots, the specific brand of backpack worn by the suspect, and persons of interest detained at a Culver's restaurant. He communicated all of it, except this. And that silence is the reason this case still doesn't make sense. 3 former FBI agents, each with federal kidnapping experience, watched that 32-day retention and reached the same professional conclusion. Something in that car was worth keeping it for. What that something was points this investigation in 3 very different directions. We will work through all 3, but hold on to that response from the Sheriff's Department. One sentence, no time frame, no forensic context, no reference to the clearance that had been announced 10 days before. We will come back to what that silence actually communicates and why it may be the most deliberate piece of language in this entire case. Start with what is documented. On the evening of January 31st, 2026, Nancy Guthrie had dinner with her daughter, Annie Guthrie, and Annie's husband, Tommaso Cian, at their home. At 9:48 in the evening, Tommaso drove Nancy back to her own residence and watched her walk inside. 2 minutes later, the garage door closed. That is the last confirmed normal moment in this case. Shortly after 1:47 in the morning on February 1st, Nancy's doorbell camera went dark. At 2:28 in the morning, her pacemaker app disconnected from her iPhone. What happened in between is what investigators have been working to establish ever since. And one of the places they looked for that answer was inside the car. The vehicle Tommaso drove that night, a silver Honda CRV, was seized by investigators in the first week of the investigation. Sheriff Nanos was direct about how it happened. The car that was at the home, it's just standard investigative practices. It's part of the search warrant scene. We pull it out of there and do our scene processing with the vehicle. Note that language. Search warrant scene. Court order, not voluntary surrender. The car was taken under judicial authorization. That is a legal distinction that becomes important later, and we will come back to it. A search warrant requires investigators to demonstrate probable cause to a judge that specific evidence relevant to a crime is likely to be found in a specific place. When a judge signs that warrant, they are agreeing that the vehicle likely contains something relevant. The seizure was not a precaution, it was a finding. At this point, that detail is not alarming on its own. Search warrants on vehicles in active kidnapping investigations are standard. Investigators sweep everything connected to the last known movements of the missing person. What became less standard was what happened after the family was cleared. And that is where the official explanation starts to thin out. February 16th, 16 days after Nancy disappeared. Nanos held his clearance press conference. The family had cooperated fully. Phones taken, computers taken, vehicles processed, homes processed. Past tense, all of it. The public heard that and reasonably concluded the vehicle question was closed. But go back and listen carefully to what Nanos said and what he did not say. He listed the phones. He listed the computers. He listed the homes. He listed the vehicles. Every item delivered in the same tense, the same framing, the same implied finality. Nothing in that sentence signaled that one of those items was still sitting in an evidence lot. For a sheriff who had been transparent about every other development in this investigation, the pacemaker, scanner, grid patterns, the DNA testing protocols, the genealogy pivot that clearance statement was understood by the press and the public as a complete accounting. It was not. The Honda CRV remained in evidence for 16 more days after that announcement. Now consider what that creates. Nanos said on February 16th that vehicles had been processed, past tense. The Honda CRV was not returned until at least early March. Either the processing was not complete on February 16th, which contradicts the past tense framing, or something in the vehicle required additional time beyond what had already been done. If the processing was done, why was it still there? And if it was not done, why was language used publicly that implied it was? Neither question has been answered. There is something else about the evidence chain worth understanding here. Federal evidence custody is not informal. Every item seized under a warrant is logged, assigned a unique evidence number, and tracked through every step of processing. Each analyst who handles the item signs for it. Every test is entered into the record. Returning an item to its owner requires a formal decision from the evidence custodian, documented, deliberate, not something that happens by accident. The Honda CRV's continued presence in the evidence lot was not the result of paperwork sitting in a stack. Someone in the chain of authority made an active decision to hold it, and continued making that decision every day. It did not come back. The confirmation that the car had eventually been returned came not through a Nanos press conference, not through an official statement from the sheriff's department, not through any of the channels Nanos had used for every other development in this case. It came through a brief report from a British outlet. No forensic findings from that vehicle have been publicly disclosed. Not what was found, not what was tested. Not why a month of processing was required, when Nancy's own Subaru, the family's phones, their computers, and their home were all processed and returned within 2 weeks. The Honda CRV was the one item in this investigation that got a month and zero public explanation. Why keep that quiet? Because if investigators kept that car for 32 days, they believed something inside it mattered. And that is the question this episode is really about. On February 27th, one day after the CBS 5 inquiry confirmed the car was still in evidence, 2 former FBI agents addressed the vehicle directly on camera. The first was Jim Fitzgerald. Fitzgerald spent 20 years as an FBI supervisory special agent, criminal profiler, and forensic linguist in the Behavioral Analysis Unit. He is the agent most credited with identifying Ted Kaczynski, the Unabomber, by applying forensic linguistic analysis to Kaczynski's manifesto. His career also included work on the JonBenet Ramsey investigation, the DC sniper case, and the anthrax letters. He spent 2 decades inside federal investigations. When someone with that background calls something odd, it is worth paying attention. His assessment of the 32-day retention was simple. There are protocols within all these departments about how long you can keep an impounded vehicle because it just gets in the way. That is odd. It must have some sort of evidentiary value to someone for some reason that it hasn't been released. It does raise some interesting red flags. And then he said something that has stayed with everyone following this case closely. If I was completely innocent, I'd hire a lawyer by now and say, I want my car back. He was not making an accusation. He was applying a pattern he had seen many times in investigations. Innocent people demand their property back through attorneys, through formal channels, publicly when necessary. 32 days without being released. No such demand was made on the public record. Does that sound normal? Because to Fitzgerald, who has been on the institutional side of those demands many times, it did not. The second former agent was Maureen O'Connell. O'Connell is also a former FBI special agent. Her credential for this specific question is volume across hundreds of vehicles in federal cases during her career. She knows what normal processing looks like, and she knows what it means when a vehicle is held past a clearance date. Her conclusion was specific. You only need it if you're going to need it for trial. For trial. Not for processing, not for administrative completeness, not for routine documentation. In O'Connell's professional framework, built across hundreds of vehicles in federal investigations, a car held past its owner's clearance date means one thing: what it contains will be used in a courtroom. She did not say whose trial, she did not name a suspect. What she identified was a forensic posture. The institutional decision to retain, and what that decision communicates to someone who has made it herself many times. There is a layer to that framework worth sitting with. When federal prosecutors build a case for trial, physical evidence from vehicles goes through a specific preparation process. Forensic reports are finalized, chain of custody documentation is assembled, and in high-profile kidnapping cases, prosecutors often choose to retain the physical vehicle itself, not just the test results. Photographs of a car are less persuasive to a jury than the car. So the question is not only what was found inside it, but whether the vehicle itself may have been designated as a trial exhibit in a prosecution that has not yet been announced publicly. O'Connell said you only hold a cleared person's car if you are going to need it for trial. 32 days of unexplained retention in her professional framework signals preparation for use in a prosecution. Preparation for whose prosecution? And for what evidence? That is where a third former agent came in and offered the most forensically detailed public analysis of this vehicle question to date. Her explanation points this investigation somewhere most people have not looked. Before the three directions, understand what federal forensic processing of a vehicle in a kidnapping case actually involves, because this is not a visual inspection. Interior surfaces are swabbed systematically: every seat, every seatbelt buckle, each door handle, the steering wheel, dashboard, rear view mirror, center console, cup holders, rear cargo area. The goal is touch DNA, microscopic biological material that transfers when a person grips or brushes against a surface, even briefly. Every person who has been inside that vehicle recently can potentially be placed there through that process. The exterior is processed for fingerprints and touch DNA at every logical point of contact: door handles, trunk latch, hood, roof, the B-pillars. The GPS unit is extracted and analyzed for the full stored location history, not just recent trips. Modern telematics systems retain time-stamped coordinates going back weeks or months, accurate to within meters, documenting every point that vehicle visited during that window. The onboard computer carries its own record door open and close events with timestamps, speed data, brake events, and in some vehicle models, whether rear doors were open and when. The car is not simply a container, it is a data recorder. And in this investigation, with more than 100 agents and analysts active and a six-figure federal reward in place, lab work is not backlogged, it is expedited. 32 days is not a processing delay, it is a decision. Here are three directions that decision could point. Before anything else, no arrest has been made, no charges filed, no suspect named. The Pima County Sheriff's Department formally cleared Tommaso Cian and the entire Guthrie family on February 16th, and that clearance has not been publicly revised. Nothing that follows is an accusation, but the forensic question has to be asked. The Honda CRV was retained for 32 days after a public clearance that used past tense processing language for every item in the family's possession, including the vehicles. If forensic processing of that vehicle produced something inconsistent with the stated timeline GPS movement data that does not match the account, unexplained biological material, touch DNA from someone who should not have been in that vehicle, then the February 16th clearance requires its own explanation. If results came back from that car after the clearance was announced, and those results raise questions, who was told and when? There are two possible explanations for a clearance that preceded inconvenient forensic results. The first is that the clearance was premature made before all forensic results had returned from the vehicle, and not publicly revisited when they did. The second is that the clearance was strategic. Law enforcement sometimes publicly clears individuals under active investigation, specifically to prevent them from understanding how close investigators are. A strategic clearance keeps a subject cooperative, keeps attorneys at bay, and keeps the investigation moving without showing any cards. There is also a layer to how GPS contradictions are handled in federal investigations. When vehicle location data is used to challenge a stated timeline, investigators do not present it immediately. They first cross-reference it against every other available data source: cell tower pings, toll records, surveillance camera, timestamps, witness accounts to build a corroborating picture. A single GPS data point can be explained away. A discrepancy confirmed independently by cell tower data and a surveillance camera on the same road at the same time is a different matter entirely. If the Honda CRV's movement data produced a timeline contradiction, the 32-day window would have been used not just to pull the GPS record, but to build a corroborating case around it before any public statement was made. Fitzgerald's behavioral observation carries particular weight in this direction. For 32 days, no attorney made a public demand for the car's return. That is a documented fact, not an inference. Investigators note that kind of observable behavior, because it is not how innocent people typically respond when their property is held by law enforcement without explanation. The absence of that demand does not prove guilt. But Fitzgerald, a man who has watched how people behave under investigative pressure for his entire federal career, used one specific word to describe it: odd. This is where the car becomes even more important. This is the framework offered by Jennifer Coffindaffer. Coffindaffer is a retired FBI special agent and former SWAT team member who has been following this case since early February. She has conducted federal searches. She understands the legal distinction between consent and probable cause at the investigative level. In early March, she published a specific analysis of the vehicle question not to raise suspicion about the family, but to offer what she believed was the most forensically grounded explanation for why an innocent family's car would be held this long. Her starting point was this: every search of Annie and Tommaso's property, their home, the Honda CRV, and their personal devices was conducted as a consent search, not under a probable cause warrant. That distinction matters more than it may appear. When law enforcement has probable cause to believe a specific person committed a federal crime, they go to a judge, they get a warrant. A warrant-based search is procedurally harder to challenge in court. A consent-based search carries an inherent legal vulnerability. A defense attorney can argue the consent was coerced or not fully informed. An FBI agent who genuinely believes a suspect committed a federal kidnapping does not ask that suspect's permission to search their home and car. They go to a judge. The fact that every search of the family's property was consent-based is, in Coffindaffer's analysis, evidence of how investigators actually viewed the family at the time those searches happened. Not suspects, cooperative family members of a victim. So why was the car held for 32 days? Coffindaffer's answer: the car may carry the forensic footprint of the kidnapper. The person who abducted Nancy Guthrie arrived at her home with a level of preparation that required advanced intelligence. The clothing, heavy-duty gloves sewn to the sleeve, face fully covered. Tight-fitting layers reflected specific knowledge of forensic exposure and how to avoid it. The timing reflected specific knowledge of the family's schedule: when Nancy would be dropped off, that she would be alone, that no family member would check on her until morning. The doorbell camera was disabled at a precise moment by someone who had enough composure inside a dark, unfamiliar space to work methodically for 41 minutes. That level of preparation does not come from passively watching a neighborhood. It comes from active, sustained intelligence gathering on the specific movements of the people closest to the target. Someone had to know when Tommaso would drop Nancy off. Someone had to know what time the Honda CRV would arrive at her driveway and what time it would leave. How do you get that information in real time, reliably, without being physically present? Coffindaffer raised 3 specific forensic scenarios. The first: a GPS tracking device placed on the exterior of the Honda CRV, not by the family, but on the family's vehicle, by whoever abducted Nancy. A tracker on that car would have provided real-time information: when the vehicle left Annie and Tommaso's house on January 31st, when it arrived at Nancy's driveway, when Tommaso drove away. That device, if recovered, would be direct physical evidence. It could be fingerprinted, DNA swabbed at the point of installation contact, traced through purchase records, analyzed for its transmission logs. And here is what makes that trail significant. GPS tracking devices recovered in federal investigations undergo a standardized forensic protocol. The device is photographed in place before removal to document how and where it was installed. The internal data log is then extracted. Most consumer-grade trackers store time-stamped location pings at intervals of 30 seconds to 5 minutes, retaining history until storage capacity is overwritten. The device's unique identifier is cross-referenced with purchase records, since most commercial trackers are registered to an account at activation. A tracking device that was purchased online, shipped to an address, activated through an account, and placed on a vehicle in the days before the abduction is not anonymous. Each of those steps creates a paper trail. A tracker found on that car does not point at the family. It points at the person who put it there. The second scenario, exterior fingerprints. If the kidnapper conducted physical surveillance in the days before February 1st, if they moved close enough to that vehicle to observe it, interact with it, or assess it, every point of contact left a potential recoverable print. The third, exterior touch DNA. Skin cells transfer on contact with any surface. Even a brief interaction with the car's exterior could have deposited biological material from someone other than Annie or Tommaso. Material that would appear unexplained in a DNA sweep of the vehicle's outer surfaces. There is one additional piece of documented evidence that connects directly to the tracker theory, and it has not received the attention it deserves. Sheriff Nanos confirmed in early March that investigators have not been able to identify a vehicle captured on a Ring camera approximately 2.5 miles from Nancy's home at around 2:28 in the morning on February 1st, the same moment her pacemaker app disconnected from her iPhone. That vehicle is unidentified. Now consider what a tracking device on the Honda CRV could tell investigators about that unidentified vehicle. If a tracker was placed on the Honda CRV before January 31st, its transmission record documents the car's movements with timestamps. Any device actively receiving that signal would also have been operating in the same geographic area during that window. The tracker's transmission history could give investigators a location for the receiving device, a geographic data point in an investigation where the 228 vehicle is one of the last undocumented mysteries. A GPS tracker found on that car would contain purchase records, placement timing, fingerprint or DNA evidence from the installation, and a full transmission log documenting the kidnapper's surveillance of the family. In federal kidnapping cases, pre-offense surveillance evidence is among the most powerful material a prosecution can present. It eliminates any claim of spontaneity. It eliminates any claim of opportunistic crime. And it proves planning, which is one of the hardest things to establish in court. If investigators found a tracking device on that car, what is the one thing they absolutely cannot do? Announce it. A device recovered and analyzed gives investigators the purchase point, the placement timing, potentially the identity of the buyer. Announcing it tells the person responsible exactly what investigators have and exactly how close they are. The silence about the vehicle is not an absence of findings. It may be the loudest possible signal that something significant was found. This is what Coffindaffer meant when she described the investigation in early March as active and red hot. That is not the language of a case waiting on genealogy results. That is the language of a case with a live forensic lead being carefully developed and a specific reason not to talk about it publicly. But silence only helps if silence protects something. And that brings us to the third direction. This is the hardest direction to sit with, but it deserves the same examination as the other two. If 32 days of forensic processing produced no tracking device, no unexplained DNA, no fingerprints from an outside party, no GPS data contradicting the family's account, no fiber or trace evidence connecting the vehicle to the abduction, then there is no professional basis for holding it past the clearance date. O'Connell's framework leaves no room for ambiguity. You hold a car because it has evidentiary value, or you release it. A vehicle kept for 32 days after a public clearance in a case where the house, the second vehicle, the phones, and the computers were all processed and returned within 2 weeks cannot be explained by lab backlog or administrative delay at this level of federal investigation. If the car held nothing, why was it held? There are two possible readings. The first, investigators held it out of an abundance of caution, a precautionary hold in an active kidnapping investigation where releasing a potentially relevant item felt premature regardless of what it contained. Law enforcement sometimes works that way, particularly in high-profile cases where the cost of releasing something prematurely outweighs the cost of holding it longer. The second reading is more troubling. The sheriff, who communicated everything else, simply chose not to communicate this. A deliberate decision was made to let this one piece of evidence return quietly, without context, without explanation, surfaced through a brief report in a British outlet rather than a press conference from the man who had publicly described helicopter altitude patterns and the brand of backpack on a suspect's back. Neither reading is satisfying. And in a case where an 84-year-old woman with a pacemaker has been missing for over a month of investigative activity with no public accounting is the worst of the three outcomes for the family. And for anyone trying to understand where this case is actually going, return to the original question. Chris Nanos used communication as an investigative tool. Every piece of information he released was a piece the public could act on, recognize a backpack, identify a route, place a vehicle at a time and location. He publicly described helicopter-mounted pacemaker scanners, their grid patterns, their altitude, their method. He announced DNA results, genealogy pivots, persons of interest, specific brands. He gave the public more updates in 5 weeks than most sheriffs give in 5 months. He understood that transparency generates tips, and he acted on that understanding consistently until he didn't. The Honda CRV is the one piece of evidence in this investigation where speaking stopped being a tool. There is a logic to that. Federal investigators apply a specific threshold to evidence disclosure. Information that generates leads, descriptions, timelines, public-facing details about suspects gets released because the return on disclosure outweighs the risk. Information connected to a specific identified suspect or a specific chain of evidence gets withheld because any disclosure narrows the window to complete the case. The threshold for silence is not the sensitivity of the evidence itself. It is whether the suspect can act on the information. Nanos disclosed the pacemaker scanner methodology because the kidnapper could not meaningfully respond to it. Disclosing specific forensic findings tied to a specific vehicle findings that connect to a specific person or a specific chain of transactions is a different calculation entirely. For every development Nanos shared publicly, there was a reason to share it. For the car, its contents, its forensic findings, there has been a reason not to, and that reason has held through the car's quiet return, through 3 more public interviews, through Nanos' own statement to NBC News on March 3rd that investigators are definitely closer. Investigators do not go quiet about specific evidence unless going quiet serves the investigation better than speaking. Jim Fitzgerald said the 32-day retention is odd, raises red flags, and that an innocent person would have demanded the car back through an attorney by now. Maureen O'Connell said, "You only keep a car if you are going to need it for trial." Jennifer Coffindaffer said it may carry the forensic footprint of the kidnapper, a device placed on the family's vehicle before the abduction that the family knew nothing about. 3 former FBI agents with federal kidnapping experience, none of them with access to what was in that evidence lot. All arriving at the same conclusion: 32 days is not standard. 32 days is a decision. And decisions in federal investigations are made because something in that car was worth deciding over. The car has been returned. The investigation has not slowed. But the question about those 32 days has never been answered. Whatever the forensic record from that car says, it has already been folded into the active work of an investigation that the people running it describe as moving toward resolution. The sheriff knows which direction the evidence points. What he has chosen not to say in a case where he has said nearly everything else may be the most telling piece of information left in this investigation. Nancy Guthrie is still missing. Her family is still waiting. The investigation is still active. The reward for information in this case now exceeds $1 million. If you have any information at all, call 1-800, call FBI. One call from one person who already holds one piece of this could be the reason Nancy comes home. You have now heard the same 3 directions the investigators are working from. You have heard what 3 former federal agents said about 32 days of unexplained retention. You have seen the forensic logic, the evidence handling logic, and the disclosure logic behind each possible outcome. Where do you land? Tell me in the comments. Which of the 3 directions makes the most sense to you and why? This audience has been paying closer attention to this case than most. I want to hear your analysis. Subscribe so you are here when the next development breaks. This case is moving, and the updates are moving faster than the official press releases.